stand here and talk myself out of a job. I mean, that just doesn't make sense. But what I will tell you is that the Municipal Claims and Tax Liens Act allows you to collect your attorney's fees. So there's really no good reason not to turn these over to your municipal solicitor. To the extent you're paying your attorney to collect these kinds of things, the attorney's fees are recoverable. All you have to do is set yourself up to collect them. So I want to talk a little bit about that. What do you actually have to do to make sure you get reimbursed your attorney's fees? The Municipal Claims and Tax Liens Act says that you need to enact a schedule of attorney's fees by ordinance. So for my municipal clients, I recommend that if you do not have a municipal claims collection ordinance, ask your solicitor to do one. It really doesn't take a lot of time. A lot of it is just reinforcing the statutory provisions that are available to us through the Municipal Claims and Tax Liens Act to allow us to basically say we're going to follow the statutory procedure for collecting these delinquencies. And you need to set out your schedule of attorney's fees. If you do that, you've basically met the first criteria, which is showing that you've told your constituents what the attorney's fees will be for municipal collection.
Let me throw a question at you.
Sure.
You can't do it by resolution. It takes an ordinance?
If you are a governing body that can enact an ordinance, you need to do it by ordinance. If you're a municipal authority and you can't do an ordinance and you do everything by resolution, it can be a resolution. But I will suggest that once you set an initial schedule of attorney's fees by ordinance and do sort of a general collection ordinance, you can amend your attorney's fees going forward by resolution if you put that in your ordinance. So you wouldn't have to do an ordinance every time you want to change your attorney's fees.
Thank you.
Sure. So the other thing that you need to do to collect your attorney's fees is you need to send the initial notices properly. And this is another reason why I think really at the end of the day, you're better off having your solicitor do this. The statute says that to collect attorney's fees, you need to send a very specific notice to delinquent property owners that is sent by certified mail that gives them 30 days to pay the delinquency in full without incurring attorney's fees, and basically advises the property owner of your intent to assess attorney's fees against them in accordance with your, hopefully, collection ordinance and schedule of attorney's fees. So if you do that, if the person pays within 30 days, completely pays the delinquency, are you, the municipality, going to pay your solicitor for sending that initial notice? Yes. But you also suddenly got paid on a delinquency within 30 days. And let's face it, by the time you guys turn over some of these delinquencies to me, you haven't been paid in a really long time. And if you get within 30 days of your solicitor sending a letter, you're able to collect a $1,000 bill or a $1,500 bill, you're not going to mind that your solicitor billed you for half an hour's worth of time for sending that notice. So that's just something to keep in mind. Sometimes the return makes it worth it to have your solicitor send that notice. If that 30-day certified mail letter is returned because it's undeliverable or it's refused, then you're required to follow up with a 10-day notice that basically contains the same information. We intend to assess attorney's fees against you, but if you pay in full within 10 days to the municipality, you will avoid those attorney's fees. That's the next step. Once you do that, if the delinquency is still unpaid, you can file your lien and you can include all your attorney's fees. And at that point, that lien does not get satisfied without payment of all the attorney's fees. So that's why I suggest to you that following the procedure from the Municipal Claims and Tax Liens Act that allows you to collect the attorney's fees will really benefit you in the long run. Some of you that I see in this audience see me far too often and talk to me far too often about collection matters, but those same people also get checks from me, reimbursing them for my attorney's fees. So something to think about. Something else to know about municipal claims is that it benefits you to do a little background work. And again, if you turn it over to your solicitor, they'll do it for you. But I really believe that a municipal lien ought to have a copy of the deed attached to it. That's because a municipal claim is not attached to whoever became delinquent. It's not attached to the property owner. It's attached to the property itself. So if this property gets transferred to a new owner and the lien hasn't been satisfied, it remains a lien on the property. One of the reasons, someone said to me, they believe that a delinquent municipal service fee, such as water or sewer, is a lien at the time it's incurred. And this act is pretty old. It goes back to the 1920s, and I can see that someone could make that argument, that it's automatically a lien. But if you don't file it with the Prothonotarys Office, you haven't put people on public notice that the claim is out there. And the advantage to filing the lien with the Prothonotarys Office is that anyone who goes to sell that property is going to find it, and you will be paid at the time of settlement, including your attorney's fees, assuming that you've had your solicitor do the work. So I do think that there's an older practice where people just sort of hoped that when the property was going to be sold or transferred, that there would be a call made to the municipality and these kinds of delinquencies would get paid. The truth is, if you want to get paid, you really need to put your lien on record. It really guarantees payment, more than any other practice. There's some pretty significant collection issues we're seeing right now that are maybe a little different than in the past, where you simply had a resident or property owner who was just not paying the bills. Now we have a lot of vacant properties, and we have a lot of foreclosures. And these do add some sort of interesting legal dilemmas for us, because if you actually want to go forward with the collection process beyond the lien, you're going to need to figure out what the legal status of the property is, and you may actually need to find those property owners even if they've vacated the property and you have no idea where they are. And that's another area where having your solicitor involved can really help, because we have legal search techniques available to us that are not available to the general public, where we certify that we are a solicitor and we are doing a search for legal purposes, and it sometimes enables us to find property owners who maybe haven't lived at the property for 2 or 3 years. And for service purposes, if you're going to go forward with the collection process, eventually you will need to serve these property owners. So having additional resources available to you to find these people can be very helpful. Your solicitor can also do some additional searching to find out if the property is in foreclosure. Now, I'm going to be honest, none of my clients like when I tell them that the property is in foreclosure. And why not? Because foreclosure takes forever. The foreclosure process can easily run 2 or more years. And that's why in those situations, it's really important that not only do you have things in place on public record, but that your solicitor could potentially make contact with a foreclosing bank to let them know that there is a municipal claim. So if there's a mortgage foreclosure action filed, making sure that at some point there is communication about that can often get you paid sooner than you might otherwise get paid if you're just dependent on a property owner. And let's face it, property owners who've walked away from the properties and their properties are in foreclosure, they don't care how many notices you send them. They're not going to pay it. They're just waiting for the bank to take their properties back. Being able to find out the status of a foreclosure and make contact with a foreclosing bank in that situation can be really helpful. You can also file municipal claims for things like curb and sidewalk replacement and paving. If you're going to file those claims, please do not delay in doing it or in turning it over to your solicitor to do it, because you only have 6 months from the date the work is done. For general water and sewer and trash, those kinds of services, you actually can, and I hate to even tell you this, but you can wait up to 3 years to file them. Please do not wait 3 years. I'm going to tell you right now, your chances of collecting are a lot better if the account is $300 or $400 delinquent than if you've waited 3 years and now you've got a $2,000 bill you're trying to collect. So I urge you to be proactive about collections. It really will diminish your overall collection rate, and your chances of getting paid quickly are much better. Just a couple other minor items. Municipal liens are good for 20 years. So it's not like you have to be in there reviving them all the time. Once it's filed, you get 20 years, and at the end of 20 years, if it's still not paid, you can actually file a suggestion of non-payment, and it revives your lien for another 20 years. So there are some people who prefer to file the municipal lien and just kind of let it sit there and hope they get paid on it. I don't really recommend that approach. I think you're better off to continue with the statutory collection process, which involves filing a writ of stare facias and allowing the property owner a 15-day period to file an affidavit of defense. That's basically a legal document. They actually get served by the sheriff that puts them on notice that you intend to proceed with your claim. If you get past that point, there's some other sort of statutory notices that need to be sent, and you can actually enter a default judgment, which is the precursor to a writ of execution, which is how you get a property on the sheriff's sale list. And I gotta be honest, a lot of you do not want to own these properties. Most municipalities are not really in the business of going through sheriff's sales and filing writs of execution, and a lot of times they're properties you don't really want, and you don't really want to end up owning them and then having to offload them. And that's where, even things like watching the sheriff's sale list can be really helpful, because if it's on the sheriff's sale list, the bank is foreclosing, and that will help you because you now have a very specific contact and you have a very specific information about what's going to happen to that property. So I hope that was helpful. Are there questions?